Okay, thank you very much. Now, to combat hate on the internet in general and Holocaust denial in particular, there are three basic recourses. One is using the internet itself to post and send information exposing Holocaust denial for what it is. The second is interfacing directly with internet businesses so that those businesses prevent the use of their business services for Holocaust denial. And the third is legislation. The second option about dealing with internet business directly, I've dealt with at length through the Global Forum on Anti-Semitism. I'm co-chair of the working group there on hate on the internet. We met our working group in Jerusalem in July, and a paper I wrote for that working group is amongst the materials that were distributed at this meeting, and I invite you to take a look at it. But what I want to talk about now is a third option, legislation, and using Canada as a case study. Now, Canada has for many years had a wide variety of laws opposing incitement to hatred on the internet. And historically, the most effective of these laws is the human rights laws with their human rights commissions and their human rights tribunals. These laws have worked effectively in combating incitement to hatred in general and Holocaust denial in particular, both on and off the internet, when other laws have not been working, and they have had a real impact on stopping the spread of hatred in Canada. But more recently, in the last few years, these laws have been abused to harass people who've been exercising legitimately their rights to free speech. And the harassment through the invoking of these human rights procedures have led many in Canada to question the value of these laws. My own view is that the problems with the laws are not so much their existence or the principles behind them as the procedures, which need tightening. There need to be changes to prevent the abuse. So what I want to do in the limited time I have is just run through some of the successes, some of the abusive complaints, and then some of the procedural changes that need to be made to prevent the abuse from continuing. Now, in terms of examples of successes, let me point to Malcolm Ross, Ernst Sundell, and Terry Long. Although there are many others. In fact, there's a fellow named Richard Warman in Canada who's actually made it a kind of a full-time hobby to go after Holocaust denial sites on the internet and get orders against them and get them, and these orders have been effective in shutting many of them down. Malcolm Ross is and was a Holocaust denier in New Brunswick, an elementary school teacher. The attorneys general refused to prosecute him for incitement to hatred. The school board did nothing about him. And so David Addis, a parent at one of the schools in the New Brunswick system, in the school district in which Ross taught, filed a complaint with the New Brunswick Human Rights Commission, claiming that by tolerating Ross, the school board had discriminated against his daughter. And there was a commission appointed through this human rights process, and the investigator found indeed that there had been discrimination, and ordered that Ross be removed from the school room. He could continue to be employed by the school district, but not as a teacher, on the basis that having him as a teacher created a poisoned environment in the school district, discriminating against the child. And that order was upheld by the Supreme Court of Canada. It went through litigation. Ernst Sundell was actually a German immigrant to Canada who made a full-time career of Holocaust denial. And originally the attorneys general refused to prosecute him. There was a private prosecution under a law that didn't require attorney general consent for false news, and he was convicted, but then the courts held the law unconstitutional. There was then a proceeding against Sundell under the Human Rights Commission. He was actually using an internet site in the United States. So it rose, it was an early internet case that rose issues about whether the commission had jurisdiction and whether they could deal with an internet site that was somewhere else, not in the country. And they assumed jurisdiction, and they said yes, they could deal with it because Zundel was here in Canada, not here in Berlin, but here in Canada. And there was an order against him. He went to the U.S. And then was deported back to Canada because he was only a visitor there and hadn't renewed his status. In Canada, he was a permanent resident. When he came back to Canada, Canada started deportation proceedings against him, basically because they called him a security risk, but basically it was because of the order against him from the Human Rights Commission that he was inciting to hatred. And the deportation proceedings were, Zundel was deported back to Germany. He had been convicted in absentia, Germany, of Holocaust denial and sentenced to 5 years, and when he came back, he went straight to jail to serve his sentence. And that was less than 5 years ago. I don't know if he's out yet, but he may still be in jail in Germany. A third case that was successful was the case of Terry Long, which was actually a case in Manitoba, in the province where I was at. Again, there was a situation where none of the recourses were working except the Human Rights Commission. Nobody else wanted to do anything. But the Human Rights Commission issued an order telling Terry Long to stop what he was doing, and he stopped it. And these commission orders end up having the force of court orders, and if they're disobeyed, the disobedience becomes contempt of court, for which you can potentially go to jail. And those are some examples of the effectiveness of the law. Now, here are some examples of abuses of the law. I should say that none of these complaints led to a judgment against the speaker, but the mere process generated a lot of time and concern and expense, of course. One complaint was against the Western Standard and the Jewish Free Press in Alberta for reprinting the Danish cartoons about Mohammed. And the complaint was made by the Islamic Supreme Council to the Alberta Human Rights Commission. That complaint was eventually dropped, but only after several years. A second complaint was against Maclean's magazine, which had reprinted an excerpt from a book that was written by Mark Stein called American Alone, where he was basically warning, I mean, it's difficult to encapsulate a book in one sentence, but basically he was warning against the threat of Islamic fundamentalism and its spread. The third complaint was, again, it's a Manitoba case against B'nai B'rith Canada, which had hosted a seminar on counterterrorism, or co-hosted it with the Higgins Institute, the Higgins Center for Counterterrorism. And the complaint was that somebody in that seminar had said something that was anti-Islamic. And that complaint was made by the executive director of the Islamic Social Services Association of the U.S. and Canada. Now, as I said, none of these complaints actually led to an adverse judgment, but they did cause a number of problems. The Maclean's one, which was made by the Canadian Islamic Conference against Maclean's, was made in 3 jurisdictions simultaneously, under 3 human rights laws at the same time: British Columbia, Ontario, and the federal Canadian system. So one problem, obviously, was the simultaneity of the complaints. And especially with the internet, which is everywhere. I mean, it's in theory, if you've got a complaint and there's legal systems everywhere, you can make all these complaints all over the world at the same time against the same person or the same organization, the same business, and throw them into litigation all over the world, and the complaint could be frivolous. So how do you deal with that? Well, the obvious answer would seem to be that there should be a requirement in the law of a choice of forum. that you have to actually choose one form and stick to it, or the law should require you to do so. Another problem that all these frivolous complaints raised was that they generated costs. I mean, the people being investigated had to defend against the charges against them, but there was no system in any of these tribunals to award costs. So even though in the end nothing happened, in a couple cases they were dismissed on their merits. In the case against Maclean's in British Columbia and in federally in Canada were dismissed on their merits, as well as the complaint against B'nai B'rith in Manitoba. But and even though Maclean's or B'nai B'rith incurred costs, we couldn't recoup costs against the complainant. So that, but again, I would suggest, I mean, that's a procedural problem. Give these jurisdictions power to award costs. A third problem, and this was a problem with the case in Manitoba, was that it was based on rumor. The actual complainant, Shahina Siddiqui, didn't attend the seminar, and she said she'd heard something from somebody who went to the seminar. We never found at B'nai B'rith Canada who she'd heard it from, so we were faced with an anonymous accuser, which is violates a basic principle of law, and so I would suggest that these laws should state that you have a right to know who your accuser is. The yet another problem was in these proceedings is lack of disclosure. That the complainant provides material to the human rights commissions or the human rights tribunals, and the commissions do not necessarily disclose the materials to the object of the complaint. They may at some later stage if it actually goes to litigation, but not in an early stage where it's going into investigation. So it becomes very difficult to answer to an investigation without disclosure. So I would say there would have to be disclosure. There was a problem in the Ontario case against Maclean's. In Ontario, they declined jurisdiction. They said they had no jurisdiction. But then the Human Rights Commissioner said, well, she thought that, that Mark Stein, even though they had no jurisdiction, had done something anti-Islamic anyways, which was, in my view, incorrect, and certainly inappropriate to issue a judgment in a case where they had no jurisdiction. So I would suggest they not they stick to their jurisdictions. But again, that's a procedural issue. In British Columbia, they had abolished the Human Rights Commission, which Human Rights Commissions tend to both conduct cases and screen cases. There's been a trend in Canada to keep human rights codes and tribunals, but to abolish commissions because the commissions generate a lot of delay. But of course, if you eliminate the commissions, you also eliminate the screening mechanism, and cases can go straight to tribunals that are frivolous, and that's indeed what happened in British Columbia with the Maclean's case. But the complainant was eventually unsuccessful, but the case had to go to a tribunal because the screening mechanism was gone, and in my view, we need to reinstate that screening mechanism. The lack of disclosure that we saw in Manitoba in terms of B'nai B'rith was not just that we didn't find out the substance of what was being sent to the commission by the complainant. We also, they appointed an independent expert to look at the material. They wouldn't tell us who the expert was. They wouldn't tell us what was submitted to the expert. And obviously we wanted to make submissions to the expert. The expert eventually said there's nothing there, and so the case was dismissed. But the process itself was disconcerting. Well, now if you look at the substance of what these complaints were, basically the complaint against the Western Standard and the Danish cartoons was an attempt to use the hate speech laws to prohibit or to hamper blasphemy against Islam, which is not the purpose of these laws. complaint against Maclean's, in my view, well, I guess it's a fairly objective assessment, because this is what happened, was that the book was complaining against Islamic fundamentalism, but the complaint was that it was directed against Muslims generally. So it was turning a criticism of Islamic fundamentalism into a criticism of Islam. And in the case of the B'nai B'rith seminar on counterterrorism, well, I mean, this is basically just a complaint about trying to be active in combating terrorism. And you can see the inhibiting effect. I mean, obviously one could have avoided these complaints by not blaspheming Islam, by not saying anything against Islamic fundamentalism, by not trying to prepare against terrorism. But those are obviously not appropriate responses. Now, my overall conclusion, though, is that the law has been effective. It's been useful in the past. It has been, I would say, effective in hampering and stopping the spread of traditional Holocaust denial and incitement to hatred in Canada. It has become subject to abuse by people who are trying to stop what they see as blasphemy against the Islamic religion, or criticism of Islamic fundamentalism, or maybe what they see as over-enthusiastic attempts to combat terrorism. And the answer, in my view, though, is not to abolish these laws, but to change the procedures so that they're less subject to abuse. If we remove the laws simply because they can potentially be abused, and I remind you, none of these abusive complaints succeeded, then I think what we're doing is harming ourselves and harming the... I see somebody's running here. The mic seems to be going on and off, but maybe I just need to talk more slowly. Oh, oh, I see. Maybe I should make more of an effort to say things that you would like to hear. But I think if we remove the laws simply because they potentially can be abused, they remove laws which can protect ourselves and our values and principles, and we need that protection. Thank you very much.